Good afternoon or good evening or good morning, depending where you are tuning in. And first, let me apologize that I am not wearing my suit, my jacket, and my tie. And I really, really apologize for that. I know that you expect more out of me, but in my building, and I'm on the 10th floor, they decided to turn off the air conditioning. So in the nice summer, hot summer day here in Michigan, they decided that they need to work on the HVAC system. And therefore, I hope you'll accept my apologies that I'm not going to wear my jacket for today's show, but I don't mean any disrespect to any of you out there. But just got to make it a little bit cooler in here. And we do have the fan going. Hopefully that's not going to affect the sound at all. But okay, let's get into it because once this dropped yesterday, it seems like everything just exploded. People are trying to figure out what's going on. And they need the voice of clarity, the voice of calm, which is probably why you've tuned in today. So we've got to provide this for you. And we're going to walk you through what exactly I believe is going on, what makes sense to me. And let's start from the very beginning. Okay, so let me just show you. You probably all saw this already, but let's just kind of go through this. So this dropped yesterday. Okay, defendant Karen reads Rule 9E, Notice of Motion to Dismiss the Plaintiff's Complaint. Pursuant to Superior Court Rule 9E, the defendant Karen Reed hereby notifies the court that she served a motion to dismiss pursuant to Superior Court Rule 9A upon all parties on July 9th. So that means that happened yesterday. July 9th was when they served this motion to dismiss, which means, quite simply, that the motion to dismiss was already drafted and it was served on the plaintiffs. Okay, so Karen Reed's defense team already drafted this motion. They may have been working on this motion for months because, there was a stay, so they could have still been working on the case. But once the stay was lifted, now that the criminal case is over, so they served this motion to dismiss. Now, you have to keep in mind that because we are in Massachusetts, everything's different. Okay, so the way it works in every other jurisdiction in the country seems to be different than the way it works in Massachusetts. So when I saw this, I was like, okay, so it must be that they filed the motion already. I mean, right, you only serve the motion once you file the motion, or it happens simultaneously. But apparently that's not the way it happens in Massachusetts. So the first question that people are wondering about is, where is this motion? Can we see this motion? Did it hit the docket? Is it going to hit the docket? When are we going to see everything so that we can get that breakdown and analysis from Brother Counsel? Well, let me explain to you how this is going to happen. Okay, so the way it works in Massachusetts is actually, like I said, a little bit different. So the way it works in Massachusetts is that actually you draft the motion, you serve it on the other side, but you don't file it yet. Okay, so in every other jurisdiction, you file it and then you serve it, where it's simultaneously at the same time that you file it, you serve it. But in Massachusetts, what happens is that you draft it, you send it to the opposition. So in this case, it would be to the plaintiffs. And then the plaintiffs get it and they say, oh, look at this motion. We better respond to it. And then they have a certain amount of time to respond to it. And I bet you're wondering, how long do they have to respond to it? Well, I'm going to show you the rules because that's what we do here. We show you the actual court rules. So this is the court rule that we're going to pull up here. It's in 9A. And it says the following. So all oppositions must be served no later than 10 days after service of the motion papers, which would mean that they have 10 days. And there is a little caveat here. They may get an extra 3 days, but let's just assume it's 10 days, that they get 10 days to respond to the motion. And by the way, if you have questions, you can already start putting them in the chat, but I want to get through a little bit before I start taking questions from the chat, but you can start already putting it in the chat, and I'll try to get to them at the end. So the other side now, the defense has 10 days, according to the court rules, unless they have special leave from the court, to respond. Okay, so they got to get to work. Because this says motions accept motions for summary judgment. Now, there's a difference between motion to dismiss and a motion for summary judgment. Okay, two different things. Motion to dismiss for failure to state a claim and a motion for summary judgment. One is after the conclusion of the discovery. So summary judgment motions happen after they already did all the discovery closed, and now you're going to argue to the court that there is no material fact that is at dispute. After all, we did all this discovery, and it turns out there's really no point of going to a jury because we fleshed this all out in discovery, and we already know everything that we need to know, and there's no case for the plaintiff, let's say. Okay, so that's a motion for summary judgment. But a motion to dismiss for failure to state a claim, which seems to be the first opportunity, instead of answering a complaint, we've spoken about this before, but instead of answering a complaint, you can file a motion to dismiss the complaint because the plaintiff did such a bad job at drafting the complaint or some other defects, some jurisdiction defects or whatever. But most of the time, it's a failure to state a claim. Okay, so that is what most likely is going on here. They're going to file this motion to state a claim. And by the way, I actually looked, and I did a video on this a long time ago about as soon as this complaint was filed, and I gave some suggestions about what types of arguments they can make, Karen Reed can make, for a motion for failure to dismiss for failure to state a claim. But let's just talk about the timing right now. Okay, so right now, all that's happened is that Karen Reed's defense team drafted this motion and sent it to the plaintiff's attorneys. The plaintiff's attorneys got it yesterday, July 9th, and that's why they have to file this notice with the court that we served this motion to the plaintiffs. Serve just means to send it over to them. We sent it over to the plaintiffs, and now they have 10 days to respond. Now, what do you think happens when they respond? Well, what happens when they respond is they send it back to Karen Reed's team. So now they have 10 days to respond. They send it back to Karen Reed's team, and now Karen Reed's team has some time to file everything with the court. So let's go back up now and look what it says here. Okay, now let's take a look. It says, within 10 days of service of the opposition, the moving party, which would be Karen Reed in this case, must either file the Rule 9A package with the court or notify all parties that motion has been withdrawn, which is not going to happen, obviously. If the moving party does not receive an opposition within 3 business days, yada, yada, okay, fine. Now, so what happens is that within 10 days of getting the opposition, then they have to file this package. The package is everything that we're talking about. So the first motion that they're sending to the defense, that they're sending to the plaintiff, and now the plaintiff's response, the opposition, which is sent back to the defendants. And now the defendants have 10 days to draft a reply, and then also they can file that. So there's going to be a motion, an opposition, and a reply that is all going to be filed as a package to the court. Now, that's not going to happen probably for another 20 days. Okay, so the plaintiff now have 10 days to respond, according to the rules, and then the Karen Reed side has another 10 days to file it and draft a reply. So we're probably looking at least 20 days, unless there's other special leave granted by the court, which still could happen. But that is the timing as we sit here today. Again, things can change, but that is how the timing works out. Okay, so we're not going to be seeing anything quite yet unless you have some connection to the Karen Reed defense team, her civil defense team. And if you do, I wouldn't mind if you send me the motion for to dismiss. I'd like to see that before everybody else. But okay, I'm not sure if you're going to share that with me, or if you have some connection to the O'Keefe side, and then you're able to contact the attorneys and get the motion that was filed, and then you can also send it right over back to me. Okay, so that is in terms of the timing. Now, let's talk about what actually this is. Like I said, this is most likely a motion to dismiss for failure to state a claim. And this is in federal rules, we call it 12b6. In Massachusetts, I believe it's also 12b6. So it's basically, like we said, the following. There's a few things that the court has to consider when they're considering a motion to dismiss for failure to state a claim. Number one, they have to only look to the complaint, which means that no, they're not going to be considering Dr. Welcher or Dr. Wolf or Dr. Rentschler or any other witnesses or discovery that may happen in this case. The court is not going to consider any of that. The court is only going to consider the complaint. They're going to look at the complaint, and they're going to determine whether there is a basis to dismiss the complaint as pled, okay, as written. That's what the court has to decide. Now, some of the things that the court does when they're looking at a motion to dismiss for failure to state a claim is, number one, they accept all the allegations as true. So despite whether you think these allegations are ridiculous and frivolous and that Karen Reed never backed her car in to hit John O'Keefe and there's so much evidence against that idea, it doesn't matter. The court doesn't consider that. The court considers all the allegations as true. And then they move on from there. That's number one. Number two, all reasonable inferences are also in favor of the plaintiff. Okay, so that's another issue that they have to understand, that the court is going to look at. All reasonable inferences that could be made are in favor of the plaintiff. And in Massachusetts, then what you look at is, after looking at that, after looking at assuming that all the allegations are true and that all reasonable inferences are taken in favor of the plaintiff, which would be the opposite. That would be the O'Keefe family in this case, not Karen Reed. So everything is going to be taken in favor of the plaintiff at this stage. Then if the O'Keefe family has made plausible allegations, which would suggest that the plaintiff is entitled to relief, then the motion to dismiss is denied. It is not allowed. So that is what we're talking about. Okay, that's most likely what's going to happen here. This is what happens very often, by the way. Instead of answering the complaint, you'll try to chisel away at least at some of the counts that are made. Now, we're going to go through some of the counts today also, but that is most likely what we have coming down in about 10 to 20, 30 days, whenever we actually see all of these motions and responses that are going to be filed. Now, I wanted to show, because I tweeted out something, and I love Ted Daniel, but I just want to talk about this and tell you why I don't think that he was advised correctly here. Okay, so let me just share with you his tweet, and I'm gonna tell you why I think it's not actually what's going to happen. Okay, so this is what Ted Daniel tweeted out. Some important context on Karen Reed's new motion to dismiss in the civil lawsuit filed by the O'Keefe family. I'm told it's an effort to bring the claim filed on behalf of O'Keefe's niece for emotional harm under the umbrella of the rest of the wrongful death lawsuit. So it's just an effort to bring the emotional harm under the umbrella of the wrongful death. This is what he has some information. And I'm going to tell you now that I don't think that that's accurate. And I'm going to tell you why. Okay. So what you have to understand first is, what are the allegations and what are the counts in the complaint? What is the O'Keefe family claiming against Karen Reed? So there's a few things. Okay. And I usually broke this up into two categories because I was ignoring kind of two of them when I was talking about this recently. But let's just, for the completeness sake, we're going to talk about all of the counts that the O'Keefe family is arguing that they're claiming Karen Reed is therefore monetarily responsible for John O'Keefe's death. Okay, so first, let me just go back to this screen. Okay, so before, I'm not going to pull up the complaint. We've got a number of different causes of action. Number one is wrongful death. That's right. Ted Daniel got that right. One of the counts here is wrongful death, which means very simply that Karen Reed negligently or recklessly caused the death of John O'Keefe. Finished. And it's wrongful. Obviously, it's wrongful if she caused the death. So that's wrongful death. Number two, there is dram shop. Dram shop, have we spoken about a lot of times in this channel, is that the bars served a visibly intoxicated person. Now, in terms of the wrongful death, let's just talk about that. In terms of the wrongful death, that claim 99.999 is going to go forward. No motion to dismiss at this point is going to be able to dismiss that complaint. Okay, but let's take a look at the other, because again, you have to take all of the allegations as true. You have to take them all as true, and therefore you have to assume that the plaintiffs are saying accurate facts, that Karen Reed actually hit John O'Keefe with her car. And if she did that, if you assume that that's true, and all reasonable inferences are taken in favor of the plaintiff, well, then you got a wrongful death lawsuit right there in front of your face. So there's no way that that's going away. But let's talk about the other actions. Dram shop, we've spoken about. that's on very, very shaky grounds, dram shop. There can definitely be an argument at this point that, well, I shouldn't say at this point, because they're going to argue that you have to do discovery and we have to see, maybe there's some witnesses. But as we all know, so maybe this is going to be more, dram shop may be more for a motion for summary judgment at the conclusion of discovery. But like I said, dram shop is on very, very shaky grounds. The bars should be able to get out of this lawsuit and not even have to go to a jury. Okay, so again, we'll see what happens, but I think I've laid out a pretty strong case why the bar should get dismissed. Let's move on to the other counts. And these are the counts where I think the motion to dismiss may have some more teeth. And then we're going to get back to Ted Daniel, why this is very different. The next two counts are negligent infliction of emotional distress. That's one, that the next count. And then the following, the last count that they are claiming in this complaint is intentional infliction of emotional distress. So there's negligent infliction of emotional distress, and then there's intentional infliction of emotional distress. They're two very different things. But before we move on to those, let's pull up the wrongful death statute. Okay, because basically what Ted Daniel was saying with this tweet, whoever gave him this information, was that the emotional harm that is being alleged in the complaint is just going to fall under the umbrella of the wrongful death complaint. And I'm going to show you why that's, in my mind, incorrect. Okay, so this is the wrongful death statute right here. This is from Massachusetts. Okay, and it says wrongful death and damages, which this is going to lay out. You can read the entire statute if you want. We're not going to, but this lays out what the damages are for wrongful death, which means if it's not here, you cannot claim this damage under wrongful death. This is what the statute says. Now, you can go look at the case law and do a lot of research on this, but this is basically what it comes down to. Okay, so let's take a look. And I just highlighted it for you. So this is the damages. Shall be liable in damages in the amount of, number one, the fair monetary value of the decedent to the persons entitled to receive the damages recovered as provided in Section 1, including but not limited to compensation for the loss of the reasonably expected net income. So how much money would John O'Keefe have continued to make services, protection, care, assistance, society, companionship, comfort, guidance, counsel, and advice of the decedent to the persons entitled to the damages recovered. So these are to John O'Keefe's niece and nephew. And, that's most significantly to those people who would have benefited out of John O'Keefe's salary, his services, his protection, his assistance, his companionship. Now, Paul can also make these type of arguments, and so can Peggy. And, but the most significant here is going to be the kids. So again, this is just for the person that we lost this person. So we lost obviously his monetary value, his net income they would have been making if he would have continued working, and then companionship and his comfort and his guidance and his counsel as kids are growing up. They need a father, right? Or a father figure. Okay, so that's number one. Number two, the reasonable funeral and burial expenses of the decedent. Okay, so that's burial expenses. Number three, punitive damages in an amount of not less than $5,000 in such case as the decedent's death was caused by the malicious, willful, wanton, or reckless conduct of the defendant or by the gross negligence of the defendant. So punitive damages also could be available. But that's it. That's the extent of the damages that are available under the wrongful death statute. One thing that you did not see here is emotional harm. Okay, emotional harm is not recoverable under the wrongful death statute. All right, so that's why I was telling you that is not correct, really, what Ted Daniel, who's ever advising Ted Daniel, that's not really, I believe, what we are going to be seeing with this motion that's going to be filed, or that was served already, but it's going to be filed with the package. That's how they do it in Massachusetts. It's the entire package is all filed together. That's why I don't think that's what we're going to be seeing. What we are going to be seeing most likely is trying to, I believe, chip away at some of the counts here. So maybe the dram shop, Karen Reed doesn't really care about, so it's not about dram shop. It's going to be either about negligent infliction of emotional distress or intentional infliction of emotional distress. Now, again, where do we look to? We only look to the four corners of the complaint. Now, Let's talk about first negligent infliction of emotional distress. Okay, and this is a situation where you have what we call bystander recovery doctrine. And actually in Massachusetts, it went through a few different changes. It used to go by the impact, and then it'd be zone of danger. We're not going to get into all that. I actually discussed it in a previous video. If you want to go check that out, it's about like a year ago. But how Massachusetts eventually ended up where they did with negligent infliction of emotional distress. And that is the following, okay? It's basically the idea of where if, let's say, somebody is standing right next to their child, and the child gets hit by a car in front of their eyes. Now, the car didn't make any contact with the parent. The car just made contact with the child, and it was in front of the parent's eyes, where he saw his own child, or she saw her own child being hit by a car and either dying or getting seriously injured. Okay, that's what we call bystander recovery doctrine. And therefore, that person who was the father or the mother or the brother, usually it's someone who's very closely related to the person who got hurt, who was right there, saw everything unfold in their eyes and saw their loved ones get hurt or seriously damaged or killed. In that situation, you can collect for this negligent infliction of emotional distress. Now, meaning all the emotional problems that the person has, can't sleep, they have other psychological problems, anxiety, depression, whatever, other things, and nightmares, things that would cause the person a lot of emotional distress because of that playing out right in front of them. That is a case of negligent infliction of emotional distress. Now, I do want to say something, and that is that this entire cause of action, negligent infliction of emotional distress, is on very shaky ground to begin with in a number of different jurisdictions. And the reason is very simple. You're always going to have people that are affected by the loss of somebody close to them. Basically, you're going to open up the floodgates. Any person who's injured is going to have a father, a brother, a mother, a sister, and they're going to be somehow emotionally affected by someone getting terribly injured. So if you want to make a heyday for all the plaintiff attorneys out there, just have a very liberal view of negligent infliction of emotional distress, because it'll never end. Someone is always going to be affected, unfortunately, by the tragic death or serious injury of a loved one. So where exactly do you draw the line? Right? So this is why certain jurisdictions actually completely do away with this entire cause of action. This entire negligent infliction of emotional distress, they do away with, because it's very difficult to draw a line. There's always going to be emotional distress. But Massachusetts, as we sit here today, still recognizes this cause of action. But even them, in the case law, you see that they're trying to really limit it in certain ways. Okay, so now this is the cause of action or intentional infliction of emotional distress we're going to get to in a moment. This is where you have emotional damage, where you can sue for emotional damage, right? The emotional distress. And it doesn't go in the wrongful death statute. It's nothing to do with it. It's a separate cause of action. There's no way to say we're going to lump this with the wrongful death. It's completely different things. Okay, that's why I'm just trying to explain to you why. I'm not sure who's advising Ted Daniel, but I don't believe that he's getting the right information here. Okay, it's two separate causes of action. So now, to understand a little bit what happened in this case. Now, nobody obviously was standing next to John O'Keefe when he got hit by the car, right? Paul wasn't there. Peggy wasn't there. Nobody was there. Kaylee nobody was next to John O'Keefe. If they were next to John O'Keefe, that's a textbook case of negligent infliction of emotional distress. So therefore, what are the attorneys going to have to do here? They're going to have to argue, well, it's still close enough in time and proximity. They saw him at the hospital, right? We know that they saw him at the hospital many, many hours later. So what about that? Is that close enough in time? It's similar enough to the other situation, which is the textbook case. Is that close enough to make an argument for negligent infliction of emotional distress? So again, you don't have to look anywhere beyond the complaint to determine this. Because again, even if we take all of the factual all the allegations as facts, this is still a question of law. Is this going to fit into the cause of action of negligent infliction of emotional distress? So again, like I said, the wrongful death, I don't believe they're going to make an argument. And if they do make an argument, it's not going to win. Wrongful death is going forward. It's not getting dismissed at this point. Dram shop's probably not getting dismissed at this point. I think that these are the two counts that they're going to go after. They may go after wrongful death just because why not? Let's try it, but it's not going to get anything. But these are the two which I think are the most interesting, and they have the best shot at. Okay, so what the courts always look to when you're talking about negligent infliction of emotional distress is how close in time and proximity was the family member to the decedent or the person who was seriously injured. So for this, I want to pull up a few cases for you, and you can kind of start to understand how this works. Okay, so first, let's go to this case. This is Fritter. And what happened in Fritter, take a look at this quote. The person here was not at the scene. Instead, this person ran to the hospital, rushed to the hospital in this case. And the courts found that this was good enough to satisfy negligent infliction of emotional distress. And this is what it says. I hope you can see the where I highlighted here. A plaintiff who rushes onto the accident scene and finds a loved one injured has no greater entitlement to compensation for that shock than a plaintiff who rushes instead to the hospital, so long as the shock follows closely on the heels of the accident. The two types of injury are equally foreseeable. So what this case lays out is that you don't have to actually be at the scene. So if the defense wants to make an argument, if Karen Reed's side wants to make an argument that, well, if Paul O'Keefe and Peggy O'Keefe were not at the scene when John O'Keefe got hit or did not discover him there at the scene, they cannot have a cause of action called negligent infliction of emotional distress. That is going to lose, because this is what the case stands for. The case says that you do not have to be there, because this is what this case says. Even if you go straight to the hospital afterwards, that is close enough, right? So now what happened, unfortunately, in this case, in the opinion, you don't see how soon after the person came to the hospital. It doesn't say it in the case. It would have been very helpful. I was hoping it would say, but it doesn't say it in the case exactly how soon after the injury or after this accident this plaintiff rushed to the hospital. Okay, and that's going to make a difference, because the closer you are in time, the better shot you have at this cause of action. Now, let's move on to another case. And this is Stockdale. Okay, so this is a case similar. Listen to what happened here. We first addressed the plaintiff's claim for negligent infliction of emotional distress. According to a death certificate submitted by Byrd in support of its motion for summary judgment, Link's death occurred on October 18th, 1978 at approximately 5:30 p.m. In the plaintiff's affidavit, which we treat as having been timely filed in opposition to Byrd's motion, the plaintiff states that she was advised of Link's death by the police at 9:30 p.m. Okay, so very important to concentrate on the time here. 5:30 is when the death happened. She was notified, the plaintiff was notified at 9:30, so 4 hours later, on the day he died, and that she immediately became very upset and began to shake and cry. Obviously, I think it was her son. The next day, at approximately 5 p.m., the plaintiff saw Link's body at the funeral home, became physically ill at the sight of the body, and thereafter suffered loss of sleep, stomach upset, and other mental and physical pain and suffering, including uncontrolled crying and shaking. Okay, so this was 5:30 was the death. She was notified at 9:30 p.m. And then around 5 p.m., so about 24 hours after the death, is when she first saw, I think it was her son, in a very bad state at the funeral. Now, she made a claim for negligent infliction of emotional distress. Now, let's see what the courts say, this court says in this case. Although the instant case can be distinguished in one particular or another from the Duzinski, Fritter, Cohen, and Miles case, we conclude that since the plaintiff did not learn of the accident until several hours after it occurred and did not see the injuries to her son's body for 24 hours, This case is more like Cohen and Miles than it is like Dusinski and Ferreter. Therefore, even without considering whether the material submitted in connection with summary judgment motion raised legitimate issue questions, whether the plaintiff indeed sustained severe mental distress or substantial physical harm within the requirements, etc., and without considering the significance of Link's age at the time of the death, we conclude that the judge correctly granted summary judgment for Bird with respect to the claim for negligent infliction of emotional distress, which means, in very simple English, that this was a case that was dismissed. The Stockdale case was dismissed. So she found out about the case she found out about the death 4 hours after, and then saw the body 24 hours. That was too far away. Okay, so now using that as if you're on Karen Reed's side, this is what you have to do, right? You got this case that says that 24 hours is too long. You got this other case that says if you rush to the hospital and see the body there, it's just like seeing the body at the scene of the accident. Well, how soon? So what about in this case, right? John O'Keefe, according to the defense, according to the plaintiffs, I guess, in the civil lawsuit, he was killed at around 12:30, 12:45 a.m. That's when he was killed. Now, Peggy was notified till around 8 o'clock in the morning, 9 o'clock in the morning. When did you get to the hospital? Around 10? It's not. I don't think it was clear from her testimony when she got there. Now, these things may get fleshed out during discovery, but the question is that going to be too far in time? Is that too far in time to make an argument for negligent infliction of emotional distress? Is it too similar to the Stockdale case where it was 24 hours later? This case was not 24 hours. It wasn't 24 hours later. It was many hours later. It wasn't at the scene. It was at the hospital. So these are types of arguments that most likely we're going to be seeing why the negligent infliction of emotional distress should be dismissed. Okay, so that's as it comes to the NIED, negligent infliction of emotional distress. Now, let's move on to the intentional infliction of emotional distress. And this, they only made this claim as it relates to Kaylee. And now I'm going to pull up the complaint for you just to show you this part about Kaylee. Okay? Intentional infliction of emotional distress is very similar to negligent, except it's worse. So let's go to the complaint. Okay? Now, if you go through the complaint, so you go all these different counts, this last count, as you see, it's Kaylee Forbush versus Karen Reed, starts off as negligent, reckless, and or intentional infliction of emotional distress. And I think that at this count, Karen Reed's defense team has the best shot at getting a dismissal at this point. The motion to failure to state a claim on intentional infliction of emotional distress, that would, now again, these are really two different causes of action. This definitely should have been split up, but they should have had one count for negligent infliction of emotional distress for Kaylee and also one count of intentional. They're different torts. They're different causes of action. Maybe that's what somebody told Ted Daniel. I'm not sure. But anyway, but you see here, this is only for Kaylee that they added this intentional infliction of emotional distress. So now take a look at what happens, well, what they argue here, what they allegations here. Okay, Kaylee learned of JJ's death or injury when defendant Reed woke Kaylee up at approximately 4:30 a.m. on January 29th, 2022. Defendant Reed knew Kaylee was vulnerable, having already lost her parents at age 6. Nevertheless, in Kaylee's presence, defendant Reed spoke on speakerphone to various people between 4:30 a.m. and 5 a.m. on January 29th, 2022. At relevant times on January 29, 2022, Kaylee heard defendant Reed say, JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I had hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. As a result of the conversations, defendant Reed had in her presence, Kaylee perceived the injuries caused to her guardian, Uncle JJ, and perceived the injury producing event. Again, this is a very big stretch here. Kaylee already perceived the injuries caused her guardian by maybe he got hit by a snowplow, maybe I hit him. You're not seeing exactly what part of him, what injuries are we talking about? Not really, but okay. At or about 5 a.m., after waking Kaylee up and informing her that something happened to JJ, defendant Reed left Kaylee home alone. Defendant Reed intentionally and or recklessly inflicted severe emotional distress when she woke up Kaylee and informed her that she hit her uncle or that a snowplow hit her uncle. Defendant Reed either intended to inflict emotional distress in Kaylee or knew or should have known that emotional distress was likely to result from Defendant Reed's conduct. Defendant Reed's conduct was extreme and outrageous, and those are important terms, which we're going to get to in a moment, beyond the bounds of decency and was utterly intolerable. These are all legal terms that they're throwing in here for a reason. Then, after JJ was declared dead, Defendant Reed came to the family house and feigned concern. Rather, it became clear that Defendant Reed was only there to collect her belongings and to take possession of the murder weapon. The emotional distress suffered by Kaylee was severe and of a nature that no reasonable person could be expected to endure it. Defendant's extreme and outrageous conduct caused Kaylee aggravated emotional distress, manifesting in physical symptoms. Kaylee also suffered severe and profound emotional injuries as a result of perceiving JJ's death and or the injurious producing event, the consequences of Reed's negligence. Then defendant outrageously created a false narrative. And there's a reason they're saying outrageous we're going to get to in a moment. But this false narrative idea that she created this false narrative, and again, if you're on the O'Keefe side, this is what you believe happened. You believe that she made this all up. She knew that she hit him, and then she made up this false narrative. Kaylee's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and approximately caused by Defendant Reed's actions. A reasonable person in the same position as Kaylee Forbich at relevant times, including the time of JJ's death, would have suffered severe and profound emotional distress. So this is where the final count of intentional infliction of emotional distress, that she woke her up in the middle of the night and told her about all this information that is going on. Now, the reason why intentional infliction of emotional distress is different than negligent infliction of emotional distress is intention is that you intended to do something. You have to have intended to do an action which is so outrageous and extreme. So, extreme and outrageous, which we're going to see in a moment. Now, you have to ask yourself, is this really extreme and outrageous? Is this extreme and outrageous that she created a narrative? Creating a narrative is extreme and outrageous? So I think that's a little bit ridiculous on its face. But just to give you a little idea, and you can do some more research on this if you want, but I pulled up one case. There's a few different cases. Some of them are really extreme and outrageous, which I don't not really appropriate for my ears, let alone some of your ears. And we try to keep this PG. But there's some pretty bad, extreme, and outrageous in the case law. But here's one example, which is okay for me. And once you kind of see what the baseline here for the courts at what extreme and outrageous is, you're going to see why the actions that Karen Reed took are not going to satisfy extreme and outrageous. Even, again, only looking at the face of the complaint, only the four corners of the complaint, which is what the judge is allowed to do in this case. That's the only place where he's allowed to look. So even assuming everything that they said there was true and that she created this false narrative and that she woke her up, it's still going to be very tough to prove that or make even an argument that this is intentional infliction of emotional distress. So here's the case. And I'm not going to read the entire case, but this is just gives you a snippet of the type of extreme and outrageous conduct that somebody has to engage in order to be found liable for intentional infliction of emotional distress. So here we go. Viewed in the light most favorable to the plaintiffs, which is what the courts have to do. A jury could find that the technologist, in this case, we're talking about someone who was suffering in pain and went to an x-ray, and we're going to hear what happened. A jury could find that the technologist understood Kara's and Margaret's concern. Those were the relatives of the person as family members about Donna's extremely vulnerable state. So Donna was in an extremely vulnerable state and then current level of pain. She was in tremendous pain, and the technologist there wanted to give her an x-ray. The technologist denied their request to allow a family member to assist or remain in the room in order to minimize any additional pain Donna might experience during the x-ray exam. And the technologist gave an assurance that they would stop if Donna asked. Failed to stop. So they said, don't worry, we're going to stop if Donna, this is the patient who's in a tremendous amount of pain and is in a very vulnerable state. They didn't allow any family member in the room to comfort her, to be with her. And then they said, don't worry, if she asks us to stop, we're going to stop. But they didn't stop, failed to stop, despite a plea from Donna to stop. So Donna's begging, please stop. Stop this x-ray. For whatever reason, maybe the position was killing her, whatever. Knew that, and then they knew that Karen Margaret waited outside the x-ray room and could hear Donna's screams of agony, returned Donna to a soiled bed, and lied about stopping the x-ray exam early in an apparent attempt to hide wrongdoing. Okay, so that's the type of, and this is, by the way, one of the less atrocious, extreme, and outrageous cases. But even in this case, you got a person who's screaming for the technologist to stop. The technologist is not stopping. The family members are outside listening to what's going on, and then they lie about it, and then they return her to a soiled bed. I mean, this is extreme and outrageous. And then you have to say, okay, well, what about waking up Kaylee in the middle of the night? What, you know, and coming up with a false narrative? Is that extreme and outrageous? So, you know, that's where I think they have the strongest case to get this dismissed, even at this juncture. Now, a lot of times when you have a motion for 12b6, you could ask the court to amend your complaint and then file a new complaint. So you have a first amended complaint. Sometimes you can amend it again after another motion to dismiss. So they can play this game a little bit where they're amending the complaint, and then there's another motion to dismiss that's filed for failure to state a claim. But most of the time, even once it gets passed, I mean, really, all you have to do is plead with some facts a cause of action, a recognizable cause of action. And that's all the judge is allowed to look to. But like we said, even in this, you have some pretty strong arguments about the intentional infliction of emotional distress for that to get dismissed at this juncture. And you also have the argument of the negligent infliction of emotional distress to also get dismissed even at this juncture. Now, again, a lot of times they argue that we need more discovery. We need to do discovery. Maybe some more facts will come out during discovery, and that's how they overcome this motion. But this is what I think we're going to see play out. We're going to see the wrongful death is not going to move anywhere. I don't even know if they're going to waste their time trying to get that dismissed at this point. But I think it's more of an argument as the NIED and the IIED. Now, somebody asked about anti-SLAPP. No, there's no basis for anti-SLAPP here, so just get that out of your mind. You're not going to be seeing anything like that in this case. Somebody also asked another interesting question, and that is, what about comparative negligence? And Massachusetts is a jurisdiction which recognizes and has a certain rule for comparative negligence, and that is the following. If the plaintiff, it's actually the same way in Michigan, if the plaintiff is more than 50% at fault for their accident, then you cannot recover any damages. Okay, you can't recover anything if you are more than 50% at fault. Now, let's say you're less than 50% at fault. So let's say you go to the jury and the jury determines Karen Reed is 60% at fault and John O'Keefe is 40% at fault, right? So then what they do is whatever amount of money is awarded, they reduce by that ratio. So Karen Reed is only going to be responsible for 60% of that verdict. So if the verdict comes back as, I don't know, $1 million, let's say, then it'll be reduced and she'll only have to pay $600,000 if they argue comparative negligence. Now, somebody asked the following question. What happens if you have, and by the way, you should put some questions in now. We'll try to get to some questions now. But let's say we have from the medical examiner, there were some conditions that were found in John O'Keefe. And I'm not going to go through the exact conditions. I didn't have the conditions. But from the medical examiner, they discovered some conditions that John O'Keefe had. So the way that would play out is the following. You're still responsible for causing someone's death, right? Even if that, the only way that you can possibly get around that is if you get an expert to say that John O'Keefe was a walking time bomb and that he was going to collapse at any point, which is going to be, again, a very difficult argument to make. Now, maybe you can get an expert to say that his life expectancy would have been less. That maybe you'll be able to do. But let's say Karen Reed's defense team can go hire an expert to say that given John O'Keefe's medical history and his conditions that were found at autopsy, this person's life expectancy would not have been another, 40 years, but would have been another 20 years. Well, then you can reduce it that way. So that is potentially out there on the table to reduce it in that way. But just the fact that somebody had a pre-existing condition, that's not going to automatically, throw out the case or argue that there's comparative negligence. Okay, let me take some of the questions here. First of all, from Florida Fan, thanks as always, BC. What is your professional opinion as how this shakes out? Again, if you're talking about specifically the motion to dismiss, most of the times motions to dismiss at this juncture, there's ways around. So like I said, they can go through this game of amending the complaint, or they can argue that they need discovery anyway. But like I said, I think the best shot is that the IIED will get dismissed. I think there's a very strong argument for that to get dismissed, even if they take everything that the complaint says as true. Still, I think that they did not make a case for that. And the NIED also, I think, is a strong complaint, although we're going to have that problem of, was this close enough in time? And you're going to have to do a lot more legal research, which I didn't have time to do today, but you have to send your legal research or legal assistants out there or law clerks to find cases which show how much time has to pass. And if certain time passes, and you find a case that says that that's too much time, and then you say, well, that's exactly how much time Peggy had before she saw, or Paul had before he saw John O'Keefe, then you can make a very strong argument that even the negligent infliction of emotional distress gets dismissed. But the wrongful death, like I said, is going forward. That is absolutely going to go forward, the wrongful death. So if that goes forward, then she will be having a trial on that, most likely, unless you have the discovery. And this is where it's going to, if you're able, there's going to be a motion for summary judgment. There will be that motion filed. So there will be a motion for summary judgment filed in after the discovery closes, and the defense is going to make the argument that it shouldn't go to a jury. But they'll probably get to a jury. That's on most cases end up getting to a jury. And then the question is, are they going to settle the case? Will she settle the case, and what the offer is going to be? Somebody asked a question here. I just want to get to this. Will Karen Reed have to testify? Right? I'm just trying to find the question here. But will Karen Reed have to testify in the civil case? The answer to that is that she will have to sit for a deposition. Okay, she's going to have to sit for a deposition, absolutely. And she's not going to be able to plead the fifth because she's already acquitted. So she's got, she's acquitted of it. So there's no reason why she's able to plead the fifth. And she's not going to plead the fifth. So there will be a very robust deposition taken of Karen Reed. You can be sure of it. And it's going to be a little tricky. I mean, Karen, she's going to have, Karen Reed's an intelligent person, but it's really open game. I mean, it's open season for Karen Reed's deposition. They're going to be able to ask her a whole lot of questions, and she's going to have to answer them. She's going to have to answer them. There's no way around that. So, yeah. Let me see what else we have here. Oh, here's the question that I saw. Melissa, does Karen Reed have to testify? So she has to take her deposition. Whether she has to testify is a different question. I mean, that's the defense can call her. The plaintiffs can potentially call her as an adverse witness. So she may be forced to testify also. But if the plaintiffs don't call her, then the defense has the option to call her or not. But her deposition will be taken, and it's going to be a lengthy deposition, I assure you. It's going to be a long one, and they're going to be asking her a ton of questions, and there's no way around it. She's going to have to answer them. Swim Gal, will jurors be placed the same as a civil case? Who doesn't know about this case now in Massachusetts? Yeah, probably everybody does. It's going to be difficult to find a jury. But it still may calm down at that point because, we have a long time. It's like a whole another year or something, like August 2026 is when the close of discovery is or something. So, Corn Pope, what about it? He was drunk. So he was partially responsible. Well, that's the question. I mean, the question is going to be whether he was drunk and therefore he is somehow comparatively negligent by her backing her car into him. Now, just by being drunk doesn't mean that you're responsible. If you're drunk on the side of a road and somebody rams their vehicle into you, you're not comparatively negligent in that case. So unless they're able to somehow tie that his actions should be, and nobody knows what he did. No one's going to be able to argue that. I mean, the defense is not going. The defense is going to be that he didn't get hit. He didn't get hit by the car. So they're not going to argue comparative negligence. Sybil says John O'Keefe went to the bar and left the kids alone. Whose fault is that? Well, it's his fault, but but the question is how is that going to play into the civil lawsuit? And the answer is it's not going to play in at all, really. Rosie, will any of the money that Karen Reed makes off deals be in jeopardy in this lawsuit? Can she protect herself? Potentially, all of her assets can be subject to this lawsuit. So potentially, yeah. But again, like I told you before, if I have the ARCA experts, I'm pretty comfortable with my position, even in a civil case. Need some Z's. Does the civil claim completely disregard the fact that she was found to not have hit him at all? Okay, so yeah, it doesn't make a difference what happened in the criminal case if that's your question. Like, if there any res judicata or anything like that? No, the answer is no, because in the criminal case the burdens are different and the standard is different, and therefore in the civil case it's basically like a redo, and they're able to put on all of the proofs. They can call Dr. Welcher if they want, if they really want, or they may get a new accident reconstructionist to actually do a reconstruction and show how this could have happened. No, it's not going to make a difference in the civil case. Can the Reed criminal experts testify in the civil trial? You bet. And most likely they are already retained by the civil team. I would assume they are. If it was me, I would be on the phone with ARCA the minute I got this case and making sure that whatever money they want, they have. and we are going to use them as experts. So I would be shocked, beyond shocked, if the ARCA experts are not retained by her civil team. So again, the other questions about him being drunk that night. Being drunk is not going to affect this case so much. I mean, it's just not. Unless you can get. I mean, the only way. I mean, and this was never suggested at all, that you can somehow get some sort of expert in there to say that he was going to die from alcohol poisoning. Like, that's not going to happen. So the fact that he was drunk, again, like if you're drunk and somebody rams their car into you and you did nothing wrong, there's no comparative negligence there. Kristen from Manhattan, appreciate you being here, Kristen. Appreciate all the support. Can Karen Reed take anyone's deposition? Jennifer McKay, Brian Higgins, Brian Albert. What discovery is she entitled to for these individuals? It's a great question, Kristen. And the answer is she should be allowed to do whatever discovery she wants. I mean, she should be, again, discovery is very liberal. So the discovery rules are usually very liberal. And therefore, if you can make an argument that this person has some information that's relevant, and even if it's not relevant right now, even if it's not admissible right now, but if it can lead to admissible evidence, you are allowed to take that person's deposition. You are allowed to get that discovery if it can reasonably lead to admissible evidence. So yes, she could take the deposition of Jennifer McCabe, Brian Higgins, Brian Albert, and anybody that she wants. And the only way that they can argue back is that they can argue back that they're going to have to argue that it's a fishing expedition and there's nothing relevant at all that these people can add. And that's going to be a tall order. So yes, I think you're right that she should be able to take the depositions of all of those people and get whatever discovery she can from these people. Great question for Kristen. MMF, can they use the video clips in the civil trial? You bet they can. Sure can. Didn't really work out for them in the criminal case, but maybe in the civil case it will. What are your thoughts about the number of civil lawyers that Karen Reed has added to her team? I only saw there was a few appearances that I saw from the same firm. Let me see if I can pull it up quickly. Where is it? Here we go. Okay, I lost it already. There was like 3 different attorneys that appeared on the same firm. That's very normal. Very normal for like 3 attorneys to appear on the same case. And were there some other attorneys that were added also? But again, it wouldn't surprise me too much in this case because the publicity and the high profile nature of this case. So everyone's going to be doing a lot more than what you generally see in ordinary civil cases. So you may need some more hands on deck. And the fact that 3 attorneys at one firm are helping out with the case is very normal. It's just that's what it is. I've had on one case of mine, I've had like 7 attorneys on the other side, and it wasn't as high profile as Karen Reed, as you can imagine. So at this stage, I don't think it's too significant. I think there's only 3, and even if there's a few more, it wouldn't be out of the ordinary. Rita Young, Brother Counsel, can Karen say, I don't recall? And the answer to that is, and this is how I always tell my witnesses before they do a deposition, is that if you don't know the answer with 100% clarity, then your answer should be either, I don't recall 100%, or would you like me to guess? Would you like me to estimate? But I always tell them, if you don't know 100%, then don't say that you don't. Don't say that you do. Don't answer the question positively when you're not 100% sure. You better be 100% sure before you say something affirmatively in the deposition. So if she doesn't recall something, then her answer should be, I don't recall. Now, I will tell you that can really get you into trouble. Okay, you have to be careful with this. This is what I tell people also. I tell the witnesses the same thing. If you can't recall everything, then it's going to look really, really bad. If your answer to every question is I don't recall, it's going to really, really look like you're hiding something, and that's what the jury's going to pick up on too. So we always prepare. I said, I want you to really think about what happened a few days before the deposition. I really want you to think about what you do know and what you don't know. If you don't know, that's completely fine. Don't guess. The worst thing you can do is guess because they most likely have the answers. Like we said, Alan Jackson, he knows the answers to his questions, and most lawyers know the answers to the questions before they ask. And if they ask you an open-ended question, even in a deposition, it's very possible that they have discovery already, some documents, which they know the answer to that question. And if you don't give them that answer, they're going to make you look like a fool and like you're lying. So yes, the answer to that is she could say she doesn't recall to whatever question she doesn't believe that she knows with 100% certainty. And some people, by the way, think that Karen Reed does not recall what happened that night because she was too drunk. Will that come out in the civil case? Maybe. Okay, I'm still trying to get some more questions here. Great question here. Will they be able to talk about the FBI investigation? Well, this is going to come down to the judge. It's the judge's call. And we know that Judge Cannoni is not going to be the judge in the civil case. And again, this is going to be a very strong argument that the plaintiffs, that the defense makes, that they should be able to bring out that ARCO is hired by the federal government, the FBI. And definitely if there's somehow that the door gets opened, they should be able to bring that out. But it's a whole different issue. It's going to be litigated. I assure you it's going to be litigated in the civil case. And there's going to be arguments both ways. And it's going to be up to the judge, whoever it is, to decide that very important question. So, can the testimony from the criminal trial be submitted in lieu of in-person testimony? No, that can't happen. You have to, if the people are available. If the people are not available, then you can start going down that road. But if the people are available, then they have to be recalled in the civil case. But you should just know, and this is, again, the next question, Lisa Paxton, what from the criminal trial can be used in the civil case? Anything that was said and anything that was said under oath, there's transcripts of that. So anything that was said ever at any time under oath can be used to impeach a witness. So if you get up in the civil trial and try to change your story, you can absolutely get impeached with whatever transcripts they have from the criminal trial. That can absolutely happen. So it's not like it's never happened. It is testimony that was given under oath, and it could be used in the civil case. But it cannot be used in lieu of testimony. You can't just say, well, we're not going to call Jennifer McCabe. We're just going to introduce her transcript from the criminal case. Here's the $1 million question. Will the civil case be televised? I don't know. I hope so. It's not going to happen till 2027 at this point. So you got a little while. So who knows what's going to happen by that time. Can Karen's team having other evidence that was restricted in criminal trial get that in more easily? And the answer to that is it depends on the judge. So I would think that Judge Cannoni was very, very restrictive about what she was allowing in, what she wasn't allowing in. When you have a different judge, it's really up to the judge's discretion. And the standard here is abuse of discretion, which means that the judge has the discretion to decide what type of evidence gets admitted. And if you can make a good argument that it should get admitted and you have a reasonable judge, well, then you have a good shot at getting a lot of the stuff that you did not see in the criminal case, which we keep hearing. There's more and more stuff that the defense team wanted to introduce in Karen Reed's criminal case, which we did not see. And we may see that in the civil case. So yeah, depending on the judge. Here's a question. Will her insurance pay her lawyers and experts in the civil trial? Yeah, so the insurance should be covering her lawyers in this case. The argument is that she hit him with the car, which would then therefore implicate the insurance company. And there's a number of times, like I said, that it says negligence in the complaint, because insurance companies don't cover intentional acts. So if they would just make the case that she intentionally hit him with the car, like they did in the criminal case, and actually I brought this up at another point. This actually may have been some good cross-examination that they could have used on some of if Paul O'Keefe, for example, was called. If Paul O'Keefe was called in the criminal trial, what they could have done is they could have showed him the complaint that was filed, by the way. The file was filed after the first verdict, the first mistrial. They could have shown that and said, you're alleging that she acted negligently, not intentionally, right? So that would get rid of the whole second degree murder charge. But if there's an argument for negligence or she was reckless in her driving, and that's what caused John O'Keefe's death, well, then the insurance would be implicated. If it comes down to intentional acts, insurance policies do not cover your intentional acts. So that could be the insurance company may be defending this under reservation of rights. I'm not sure. I mean, this is something that we're probably not going to get the answer to. But my best answer is it could be the insurance is involved and could be the insurance is not involved. I believe it comes down to, negligence or intention. Kristen from Manhattan again. In civil cases, there are sometimes less jurors than criminal. Do you know if the jury will consist of 6? I presume all jurors must vote the same way to render a verdict. Okay, so the way it works in civil cases, yeah, it depends on the jurisdiction. I don't know what Massachusetts does. And could be this case they'll have a number of alternates also. I just have to look at exactly see what Massachusetts does. But yeah, it's not always 12. So I have to see what that is. Do they all have to come down on the same side? So again, it comes down to the jurisdiction. The default is that it does have to be unanimous. However, very often there are agreements, stipulations with the attorneys that they will accept a verdict that is not unanimous in a civil case. So, for example, let's say 5 out of, depending how many your jury's on, 7 or 8. Let's say we'll take 5 out of 8. As soon as 5 agree, we'll have a verdict. So I have to do a little bit more research on that, how Massachusetts works specifically. But what I've seen in my practice is that we will most of the time agree that as soon as we have whatever, let's say 5 out of 7 or 5 out of 8, whatever the jurors are, or 5 out of 6, that's what will take our verdict, and whether it's in my favor or the other side's favor. And usually that's works. I don't know if that's going to be in Massachusetts. I have to take a look at that. With no accident report filed with Karen Reed's insurance company, how will that impact the civil case? So most of the time, and I do mostly civil litigation now, most of the time you have an accident report or a police report. And that usually happens at the scene. When there's an accident, the police are called. When you don't have that, you already have a much harder burden as the plaintiff. Okay, I represent plaintiffs. So you have a much harder time as a plaintiff to prove your case, because after all, why weren't the police called? Why didn't the police come out and see what was going on? Why didn't anybody call them if this actually happened? So yes, it could be a problem. And it makes it, but in this specific situation, it can be explained away as who's going to call the cops? How is it going to be an accident report if John's dead and Karen's running off with a car? Like a hit and run. Hit and runs happen all the time. So a hit and run, if there's no accident report, it's fine. You continue. And it doesn't stop the litigation. Are the bars, the waterfall, etc., in the same lawsuit as Karen Reed? Are they tried simultaneously? You could make a motion to bifurcate that, but it doesn't make sense. So the motion could be filed to bifurcate the trials, but there most likely will only be one trial. I mean, if they all get, and again, like I said, I think the bars should be able to get out of this. I think the bars for summary judgment is ripe for summary judgment for them to get out of this case. Definitely the waterfall. I think the waterfall is should definitely be out of this lawsuit. But I think even C.F. McCarthy's, based on all the evidence that we saw and heard from testimony that she wasn't, did not look visibly intoxicated at all. And from the surveillance, there's the bar should be out of it. But if they actually get to trial, it's most likely going to be one trial. Real Tea with Krista Marie. Sorry, can you see my questions? I forgot to put question marks. About 7 people who would have seen him dying on the lawn didn't render aid if they wanted to claim he was there. Yes, all these arguments we're going to hear most likely again. We're mostly going to hear these arguments, and it can all be brought out again in the civil trial, in the civil case. And all these depositions will be taken. So Jennifer McCabe and everyone that was in the house, their depositions could be taken. That's all these good points that you bring up are all going to still be there. Okay, well, guys, we're coming over the hour mark at this point, which is a little bit long for me. In my videos, I like to keep them under an hour. But when we have these lives and we have very important things to talk about, so that's going to be it for now. Thank you all for tuning in. It was a little bit short notice today. And we'll see what happens next with this. We'll obviously keep watching. And we'll see you next time. All right. There's always going to be action with the Karen Reed case. So we'll see what happens next time. Thank you all for joining, and we'll see you.